Welcome to our Employment Law Microlearning, a quick dive into the key things every new HR pro should know about navigating workplace law in Canada. Whether you're prepping for your first HR internship or stepping into a generalist role, one truth stays the same. If you don't know the law, you can't protect your people or your company. But don't worry, we're not just throwing legal jargon at you. First, we'll show you a scene. A manager terminates someone in the hallway. It's awkward. It's rushed. It's wrong. Then we'll walk through what Canadian employment law actually says, from notice periods to just cause, ESA to common law, and how to avoid costly mistakes that damage trust and trigger lawsuits. Because as future HR leaders, it's not just about checking boxes. It's about knowing when something feels off and having the knowledge to stop it in its tracks. Let's start with what not to do.
Hey Jude, quick thing. We've decided to let you go. Today's your last day. Drop your laptop off with IT.
Wait, what? No warning, no meeting. You're firing me in the hallway?
It's just not working out. It's nothing personal. You'll get your 2 weeks' notice or something, I think.
Is this even legal?
Actually, no. That's not how it works in Canada. Here's what the law says. You can't just fire someone in a hallway and call it a day. If it's without cause, the employee is entitled to written notice or pay in lieu based on how long they've been with you. If it's just cause, that has to be serious, like misconduct, not just it's not working out. And under Canadian law, there's also ESA termination pay, and possibly common law severance, which can add up fast. And firing someone in public? That's not just shady. It could breach your duty of good faith and open you up to a lawsuit.
Here's the truth. If you work in HR, you're not just a people person. You're a compliance risk manager. One wrong move in a contract, a termination, or a scheduling decision can cost the company thousands. But don't panic. We'll walk through key legal essentials every HR pro should know to navigate Canadian HR with confidence and clarity. The Employment Standards Act, or ESA, is your non-negotiable baseline. It sets the minimums for hours of work, breaks and overtime, vacation time, leaves like pregnancy, sick, and bereavement, termination notice and pay, public holiday rules. These aren't guidelines, they're enforceable rights, and they vary by province. Here's an example. In Ontario, employees who've worked more than 5 years may be entitled to severance pay in addition to termination pay. In Quebec, the Civil Code applies instead of the ESA, with stricter rules on termination without notice. Employment laws vary across Canada. Make sure you're familiar with the rules in your province. Not all contracts are created equal. An unclear or poorly written employment agreement doesn't just look bad. It can cost your company in court. Imagine this. An employee is let go and their contract doesn't clearly limit notice to ESA minimums. Now they're suing for common law severance and winning up to a year's pay. Another common misstep? Labeling someone as an independent contractor when they're legally an employee. It might seem harmless, but it's not. If the person reports to you, works your hours, and uses your tools, they're probably an employee. Misclassify them, and you're risking CRA audits, retroactive benefits, and thousands in penalties. Bottom line, titles don't matter, legal definitions do. Let's clear up a big HR myth. You can't just fire someone at any time for any reason, even if you pay them. In Canada, there's a legal difference between just cause and without cause. Just cause means serious misconduct, like theft or harassment, and no notice or severance is owed. But that bar is high. If you can't prove it, you risk a wrongful dismissal claim. Without cause, that's for business reasons, like restructuring or performance. In that case, you must provide written notice or pay in lieu, and possibly common law notice if the contract doesn't limit it. Bottom line, know the difference and always document the why. It's not just what you do, it's how you do it. The law expects employers to act in good faith during termination. That means treat people with dignity, avoid surprises or public embarrassment, communicate clearly and respectfully. Get it wrong, and it's not just a bad look, it could cost you in court. At the end of the day, HR isn't just about policies, it's about people. Knowing the law isn't a nice to have. It's how we build trust, protect teams, and lead with integrity. So whether you're supporting a new hire, writing a contract, or navigating a tough termination, know the law, apply it with care. And remember, doing HR right means doing it right from the start.